Our two speakers are now mic'd up, so we shall begin. Now, our speaker and commentator here really do need no introduction, so I will not attempt to make one. We've been discussing how late we are already, so I shall not allow us to get any later and hand you straight over to our speaker, Professor Christoph Schreuer, please.
Thank you very much. The title of our panel is Controlling the Arbitration Process. The idea that investment arbitration needs to be brought under control is not uncommon. It's one of the reactions to the public hostility towards arbitration triggered by the debate surrounding the TTIP. Short of its outright abolition, control appears to at least lessen the perceived evil of investment arbitration. Inevitably, this leads to the question, control by whom? One way of controlling arbitration is through judicial review, such as annulment, setting aside, or some sort of an appeal. Another form of controlling investment arbitration is through giving more latitude to states at the cost of the discretion of tribunals. I will speak only about the second rather than the first form of control. Of course, there's a certain paradox about states controlling the activity of investment tribunals. After all, investment tribunals are meant to control state measures against investors. Therefore, it may be more appropriate to speak about harnessing the competence of tribunals, or to borrow an expression from US constitutional law about checks and balances. The EU proposal that was first published in September 2015 for an investment chapter in the TTIP contains several provisions that are designed to restrain the powers of investment tribunals. These include an explicit mention of the state's right to regulate in order to achieve legitimate policy objectives and the right of states to change their regulatory framework. Now, at that level of abstraction, the respective provisions probably address a phantom problem. Tribunals have never cast doubt in principle upon the right to regulate and upon the right of states to adjust their regulatory framework for legitimate policy objectives. The dispute turned about the question of whether in the particular case the objectives were indeed legitimate. Let me turn towards two more specific provisions in the EU proposals. The provision about the remedies a tribunal may grant against a state, and the possibility for binding official interpretations of the treaty by a body to be established for that purpose. First, remedies. Under the EU proposal, where a tribunal finds a breach, it may only award monetary damages plus interest, and in case of an expropriation, restitution, in which case the respondent state may opt for monetary damages instead. If we look at the International Law Commission's articles on state responsibility, we see three forms of reparation: restitution, compensation, and satisfaction. That's Article 34 to 37. Restitution is to be the primary remedy. Compensation is due insofar as restitution does not make good the damage, and satisfaction is subsidiary to restitution and compensation. The obligation to give satisfaction exists insofar as restitution or compensation do not provide for a remedy. In the practice of investment tribunals, compensation is so dominant that it often eclipses the other remedies. So much so that the availability of non-pecuniary remedies is sometimes contested. But the travaux préparatoires to the Exit Convention and tribunal practice confirm that restitution and other forms of specific performance are available in principle. Under the ILC articles, restitution is subject to serious limitations. Article 35 lists two such limitations. The restitution is available only if it is not materially impossible, and restitution is available only if it does not involve a disproportionate burden compared to compensation. In a number of investment cases, tribunals have found that restitution was indeed materially impossible. Some tribunals found that the respondent state's sovereignty made an order of restitution or specific performance either impossible or would be a disproportionate interference. Now, the idea of giving one of the parties a choice of remedies is not new. Article 43 of the ILC article states that the injured party may specify what form of reparation should take. In investment cases, it is usually not the injured party, but the claimant, but the respondent state that is given the choice how to discharge its obligations. For instance, Article 1135(1) of the NAFTA provides that a tribunal may award monetary compensation and restitution either separately or in combination, and if the tribunal awards restitution of property, and I quote, "the award shall provide that the disputing party may pay monetary damages and any applicable interest in lieu of restitution." The US model bit of 2012 contains a similar provision on the choice of remedies by the respondent states, and the Energy Charter Treaty also contains a similar provision with respect to remedies for measures of subnational entities. But even without specific treaty authorization, some tribunals have offered respondent states a choice of means to make reparation. In some cases, the tribunals ordered specific performance, but the performance related to the payment of money. These orders of restitution or specific performance concerned the non-collection of taxes illegally assessed, the return of money illegally collected, or the payment of money improperly withheld. In these cases, the tribunal's orders were clearly distinct from damages awards. They were directed at the non-collection, restitution, and payment of money by way of specific performance. But in economic terms, the orders at restitution of money and specific performance to pay money resemble compensation, and they do not raise the problems of sovereign discretion associated with other forms of remedies. In fact, there are very few investment cases that can be described as ordering genuine restitution of property. One of them is the historic award Topco vs. Libya of 1977. Arbitrator Dupuy did indeed find that specific performance of the concession contract was the appropriate remedy, but the dispute was ultimately settled on different terms. Another case that involves an order of specific performance was ATA versus Jordan. The order concerned the restoration of the right to arbitrate. Therefore, restitution of property through an order of an investment tribunal, although possible in principle, would be highly unusual. Restricting restitution by giving the respondent state the possibility to opt for monetary compensation instead does not seriously curtail the tribunal's powers, nor does it affect investor rights in a fundamental way. Before leaving remedies, let me make a brief remark about satisfaction. Of the three forms of relief listed in the ILC articles, restitution, compensation, and satisfaction, that is, satisfaction in the form of declaratory relief gets the least attention. Therefore, it is hardly surprising that the EU proposal does not even mention it. Satisfaction is primarily a psychological concept. However, its practical significance should not be underestimated. Satisfaction can take many forms, such as an apology or public admission of fault, but an important form of satisfaction is a judicial pronouncement. The commentary to Article 37 of the ILC article states, and I quote, "One of the most common modalities of satisfaction in the case of moral or non-material injury to the state is a declaration of wrongfulness of the act by a competent court or tribunal." End of quote. The significance of satisfaction as a remedy differs widely in different forms of international adjudication. In proceedings before the International Court of Justice, satisfaction in the form of declaratory relief is the standard remedy. Before human rights courts, such as the European Court of Human Rights, the situation is slightly different. A declaration of wrongfulness by the court is the dominant form of relief, but the court may, where appropriate, grant financial compensation if domestic law does not allow complete reparation. In investment arbitration, a judicial declaration may be just preliminary to a decision on compensation. However, in some situations, it is a remedy in its own right. Tribunals have confirmed that declaratory relief is available in principle, even where it was impossible to prove material damage. In a number of cases, the tribunals found that the host state had breached their obligations, but when they reached the quantum stage, they found that they were unable to identify any quantifiable damage. Therefore, the finding of liability was the only available remedy. In some cases, the respondent asked for monetary compensation for the moral damage it had suffered in the face of a claim that was blatantly unmeritorious. The tribunals declined to grant monetary compensation, finding that their awards provided a form of satisfaction. In a wider sense, all cases in which tribunals reject claims on the merits afford a form of satisfaction to respondent states. Remedies versus Romania is one of the rare cases where a tribunal explicitly recognized that its finding of a breach amounted to a remedy in its own right. The tribunal said, and I quote, "The claim of declaratory relief retained an independent existence of its own, irrespective of the question of consequential loss or damage." End of quote. Therefore, a declaration of wrongfulness by a court or tribunal may act as a form of reparation that is independent of and in additional to damages. The same is true of a finding that the host state has acted lawfully. In both situations, the winning party will draw satisfaction not merely in a legal sense, but also in a personal, emotional sense. For an aggrieved investor, an official confirmation that the host state has indeed acted impermissibly may well be as important as, or more important than, financial indemnity. Conversely, a host state will feel gratified by a tribunal's finding that its legal system is in conformity with international standards and that its organs have acted in accordance with its international obligations. Let me now turn to binding decisions of states, really quite a different topic. The EU proposal also contains a clause providing for binding interpretative decisions by a committee. That's, if you have the text in front of you, that's Section 3, Article 13, Paragraph 5. The EU proposal foresees these binding interpretations, but these binding interpretations by organs composed of representatives of states, parties to it, is not a new idea. The best known example for such a mechanism is Article 1131(2) of the NAFTA, under which the Free Trade Commission, a body composed of representatives of the three states parties, can adopt binding interpretations of the treaty. The ASEAN Comprehensive Investment Agreement of 2009, incidentally, similarly provides for binding interpretations through joint decisions of the parties. Some bits, including the US model bid of 2012, contain similar provisions on binding interpretations by the states' parties. Now, the technique of official interpretations by the parties subsequent to the conclusion of a treaty is in line with the law of treaties. Article 31.3 of the Vienna Convention on the Law of Treaties, dealing with the interpretation of treaties, provides, and I quote, "There shall be taken into account, together with the context, A, any subsequent agreement between the parties regarding the interpretation of the treaty or the application of its provisions, B, any subsequent practice in the application of the treaty which establishes the agreement of the parties regarding its interpretation." There is an important difference between the general provision on subsequent interpretative agreements under the Vienna Convention and the special treaty provisions on official interpretations, such as in the NAFTA. Under the general law of treaties as reflected in the Vienna Convention, the joint interpretation of the parties shall be taken into account. That's a relatively soft provision. Under the specialized provisions as reflected in NAFTA and as contained in the EU proposal for TTIP, an official interpretation shall have binding effect, a much harder provision, if you like. Of course, joint interpretations by the states parties to the treaty are possible also without a specific provision in the treaty in questions. The two states parties to a BIT may issue a joint statement on questions of interpretation. In CME versus Czech Republic, the BIT between the Czech Republic and the Netherlands provided for consultations with a view to resolving any issue of interpretation and application of the treaty. After the tribunal had issued a partial award, the two states issued agreed minutes containing a common position on the BIT's interpretation. In its final award, the tribunal took this joint statement into account. Similar procedure was followed in Eastern Sugar, although that also against the Czech Republic, although there the agreed minutes were issued before the institution of proceedings. Another issue of primarily theoretical significance is the distinction between a subsequent agreement regarding the treaty's interpretation and a subsequent practice which establishes an agreement of the parties regarding the treaty's interpretation. That corresponds to Article 31.3a and Article 31.3b of the Vienna Convention. Interesting case here is Canadian Cattlemen for Fair Trade versus the United States. There, the respondent relied on a number of unilateral statements as well as on submissions in other cases of the three NAFTA parties, but there was no formal interpretation by the Free Trade Commission under Article 1131.2. The tribunal found that there was no subsequent agreement, but held that there was subsequent practice establishing the agreement of the NAFTA parties on the issue. Joint declarations of the states parties to the agreement may appear efficient and look like a convenient method to settle questions of treaty interpretations. But if the question is relevant to pending proceedings, such an interpretation gives rise to serious concerns about the fairness of the procedure before the investor state tribunal. Once a case is underway, a state that is the respondent in the investor state proceedings is motivated primarily by defensive concerns related to the pending disputes. It will promote a particular interpretation not because it believes in its intrinsic correctness, but because it is helpful to its endeavor to win the case. the disputing investor's home state is typically less interested in an interpretation favorable to its national in the pending dispute than in an interpretation that favors state respondents generally. A good example is Pope and Talbot versus Canada, which triggered the famous FTC interpretation of Article 1105 of the NAFTA, which was clearly designed to sway the decision in Pope and Talbot in a particular direction. Let me come to an end. The two issues discussed here under the label of controlling the arbitration process lead me to quite different conclusions. The restriction of a tribunal's power to grant certain remedies is unspectacular and largely inconsequential. By contrast, mechanisms providing for binding decisions by the states parties to a treaty about its interpretation should be treated with caution. These mechanisms are questionable if one of the states issuing the declaration is a party to an ongoing dispute and stands to benefit from the interpretation mandated by it. Thank you.
Thank you very much. And again, thank you for keeping so well to time. Well, I'll hand straight over to Professor Alain Pellet.
Thank you. Good morning. First, an announcement. You will have found in your files a comparative table of certain treaty and draft treaty provisions related to the control of the arbitration process. This is the basis on what I have based myself on this table to comment Professor Schreuer's presentation. And before really going to that, a very general remark. As rightly, I think, noted by Blerina Xeraj, clearly the investment law, in fact, international investment law, has been invented in the mid-60s and the 70s in order to bypass the jurisdiction of national courts in the third world, newly independent states. And as very aptly recalled this morning by Jeremy Sharp, now developed Western states have realized that they can be defendants, and that after all, controlling the process is not a bad idea, and this is why we are here. I think this general framework is important to be kept in mind. Now, more precisely, clearly, arbitration envisaged by the negotiators of the future TTIP has not a good image in the public opinion. Remember Ms. Weber yesterday. And for continuing my aborted conversation with her, I would say that even in spite of this bad image that she represented very clearly yesterday, I would say that when you are faced with arch criticisms, just try this little trick and ask your European interlocutor, especially if he or she is a company leader or a banker, whether he or she would enthusiastically welcome that his or her firm, or himself or herself, be sued in US courts. There is little doubt that his or her hostility to an international arbitration process would not a bit weaken, fade. And makes the same experience with a US entrepreneur or manager. You will get the same reaction if the matter is raised in similar terms. So I think the conclusion is obvious. Arbitration might not be ideal. It is, I would think, the worst system for settling investor-state disputes, except for all the others. Now, this does not mean that compared with the exit system and other, even less systematic means for settling investment dispute, improvement are excluded, and controlling the arbitration process might be a means to appease the critiques, provided that you do not throw out the baby with the bathwater. And I certainly share Professor Schreuer's underlying position that you must not change an effective system just for the sake of appeasing critiques. This said, it's not fun, because globally I agree with what has been said, and when a commentator agrees with the main speaker, it's not fun. So I have tried to find some points of disagreement. My disagreement is more, in fact, on your focusing on these 2 points, which I think are not the main issues for controlling. So I will express my global agreement with Professor Schreuer on his 2 points, and then I will go to the missing points. On the 2 first points, I will be maybe, as usual, a bit more brutal in expressing my views, but they are not very different. Concerning the first one, remedies, yes, there are 3 conceivable forms of reparation in case of a state's internationally wrongful act, and although the 2001 ILC article specifies that part 2 on the content of the international responsibility of a state is and I quote, without prejudice to any right arising from the international responsibility of a state which may accrue directly to any person or entity other than a state, these 3 forms, I agree, apply in investment law. Yes, also, there is no reason why investment arbitral tribunals, including within the framework of the TTIP, must resort would not resort to all 3 when appropriate. Yes, also, contrary to the most debatable 1977 Texaco award, which I have always disapproved, restitution should be used with the utmost caution when the interests of a sovereign states are at stake, which will be usually the case. On the contrary, there is certainly no inconvenience in resorting more largely to satisfaction when the damage is not financially accessible. And finally, yes, it might not be a bad idea to offer a choice to defendant states between restitution and compensation on the model of NAFTA. I am also globally in agreement with Professor Schreuer, with what Professor Schreuer had to say on binding decisions by states. But I would put it a bit more bluntly than he did. I find that the very idea is unfair for the investors. It is often said that international investment law is too favorable to the investors, but I have the feeling that if the EU proposal contained in Article 13.5 were to be adopted, the pendulum would swing too far in the opposite direction, and I share Professor Schreuer's concern that such a mechanism would hardly be compatible with the maxim nemo judex, even if there are precedents. Mystery still surrounds the composition of the functioning and the precise competence of the committee mentioned in Article 13.5 of the European draft TTIP, even though it seems to be inspired by the TPP Commission established by Article 27.1 TPP. In any case, I think a difference must be made depending on the moment when this apparently intergovernmental body would intervene. When an interpretation issue arises outside or before any contentious proceedings. Well, if so, no objection, I think, to interpretation, and it can be accepted that such an interpretation must be taken into account by the arbitral tribunals as part of the subsequent practice, I don't think it's an agreement, within the meaning of Article 31(3)b of the Vienna Convention on the Law of Treaties. And I do not see a real objection to such an interpretation being rendered binding by an express provision of the TTIP as envisaged. But if this advisory, or even worse, binding interpretation, is to take place during an arbitral proceedings, then it would be, I think, highly inappropriate. You cannot change the rules when the game is ongoing. And the 2001 FTC interpretation in Article 1105 NAFTA falls within this second hypothesis, and I can understand the hesitations of the Pope and Talbot tribunal in accepting this interpretation. I know I have 5 minutes left, given in the course of the proceedings. I now come to my third point, Professor Schreuer's silences. There are many, and as time is short, I will rather enumerate them than really deal with them, but we can come back to some of them during the discussion, if discussion there is. First, our excellent speaker dealt, I think, rather dismissively with the EU proposal to formally enshrine in the treaty the right to regulate. Tribunals, he said, have never cast doubt in principle upon the right to regulate. Well, I'm afraid things are not as clear-cut as he makes them. I certainly accept that the right to regulate, or the doctrine of police powers, has established itself as an enforceable legal principle through both the case law and the newly adopted BITs. However, it still is a rather recent doctrine, and some tribunals still challenge it, which make me think that it is not entirely a phantom problem. Second, I go quickly because the chair is terrible. Second, in my view, important issue that Professor Schreuer has overlooked, but he might have been guided by the subtitle given to our panel. I have in mind the two-stage proceedings, first instance, second instance. Indeed, this has been dealt with by previous panels. It will probably be dealt with again later today. However, it seems to me that it cannot be ignored when you speak of controlling the arbitration process. Clearly, instituting a double degree of jurisdiction or the alternative system of provisional awards are indeed ways to control the arbitration process, both in connection with individual cases and at the global level. One of the most frequently criticized weaknesses of the existing investment arbitral system, or non-system, is its dispersion, which is no doubt a source for uncertainty as to the applicable law and the outcome of the dispute settlement. When each arbitral tribunal defines itself as being sovereign, when ad hoc committees consider, quote, the annulment mechanism is not designed to bring about consistency in the interpretation and application of international investment law, there is no way to overcome this very unfortunate turmoil. So I think that instituting a double degree of jurisdiction, each being composed of permanent judges, certainly would strongly contribute to unifying the case law. But this, I think, would be to the detriment of flexibility, which is a trademark and the main advantage characterizing arbitration compared with judicial settlement. As for me, and without having time to insist, I would rather advocate a mixed system inspired but improving the exit review mechanism to make it short, a permanent body, not ad hoc committees, vested with the exclusive function of reviewing causes for annulment in the manner of a court of cassation and not of holding a second trial. And I think that to that end, Article 52.1 of the ICSID Convention can constitute a useful guideline with some adjunction as provided for in Article 29, paragraph 1 of the EU proposal. Now, the possibility for non-disputing parties to make submissions on issues regarding the interpretation of the treaty as provided for in Article 22.3 of the EU draft, which is clearly inspired by the 2012 US model bit, is also, I think, a useful means to ensure both a better acceptability and a better consistency of arbitral interpretation. Before concluding, I just mention two other elements which in some respects could, I think, contribute to controlling the arbitration process. In the first place, and special to the TTIP, and for an obvious reasons, I think that the modalities for determining the respondent provided for in Article 5, which leaves to the European Union this determination, being underlined that the tribunal and the appeal tribunal shall be bound by this determination, is rather fortunate. And in the second place, I note that Article 21, also special to the TTIP, provides for the possibility for the tribunal to, quote, order the claimant to post security for all or part of the costs under the threat of suspension or terminations of the proceeding. These two is a means at the disposal of the tribunal, not of the parties, of controlling the effectiveness of the process. I have to conclude, and quickly, in order to not to unduly extend the extra time generously granted by the chair. First, for the time being, investment tribunals are largely out of control of the parties to the funding treaties, which is not without drawbacks. Second, a better control of the process by the parties to the TTIP would be welcome inasmuch as it could facilitate a better predictability and consistency of the decisions. But, three, and last, we must, I think, be wary of the inconveniences of falling under the other extreme, which would deprive ISDS of the main advantage of arbitration, that is flexibility. Thank you.
Thank you. Well, we still have time for questions, so I'll throw it open to the floor. There is a roving mic somewhere, and it looks like Alain.
Yeah, thank you. I have, in fact, two questions regarding binding interpretations. I very well understand the concerns which have been expressed regarding time and not having an interpretation troubling the proceedings when they are open. But at the international level, most of the disputes can be anticipated. So when do you know that the binding interpretation doesn't aim at troubling a specific dispute, even before the proceedings begin? I mean, the problem is it's a slippery slope, I think, trying to find a time limit when it's possible to have a binding interpretation and it's not possible anymore. So I understand your objection, but I have the impression that you stay in the middle of the bridge, if I can put it like this, translating French. And so this is one question, and another question is related to what you said in relation to the double degree of jurisdiction, and is related to what Stefan said a moment ago, the risk of a multiplication of permanent bodies within bilateral systems. And there we have this, if we have this kind of multiplication, I mean, shouldn't it be an obstacle to your proposition and to this flexibility, because you would have these permanent bodies acting for the sake of consistency and continuity, but in a dispersed way or fragmented way. So aren't we at risk of multiplying the risk instead of remedying to them? So, but I would be also happy to hear the view of Colin Brown of this, because we have had several remarks calling, I think, from small insight from the European Commission, if he is ready to speak.
Well, Colin's obviously having the spotlight put on him, so...
Thank you. I actually had a question which is a very close follow, or very closely related to what Helene has just asked. First of all, on the binding interpretation, the question that I had was more, we understand if you want, the policy concern that you're raising. What happens if there's an ongoing case and there's a binding interpretation come in? I think I wanted to pose a question more legally, in the sense that this is an interpretation of the agreement. It's not an amendment of the agreement. So the parties are saying, Article X has always meant this thing. So, is that something that the investors can actually legally object to? I'd be interested in you thinking on that. In policy terms, I think the EU is conscious of that issue, and you will see this is one of the differences between the US approach and the EU approach, that at the end of the relevant provision in the TTIP text, there's a reference to the committee possibly deciding that the binding interpretation have effect from a particular date. And that is something that we came up with the European Court of Justice's occasional practice and interpretations in mind. That's where that idea came from. So I just wanted to flag that particular issue. On Helen's to comment, indeed is the case that if we multiply these courts on a bilateral basis, to some extent that will indeed solidify the fragmentation to the extent that the underlying agreements are actually substantially different. But the logic behind this idea that we're also working on of creating a permanent multilateral court is precisely to start to try to remedy some of these issues. Thank you.
Professor Schreuer, perhaps you want to go first?
First, just one remark on Alain Pellet's criticism of the points I focused on. You're absolutely right. Those are probably not the most important points, but I got a very specific assignment from the organizers of this conference, and I was just being an obedient pupil who did his homework.
Which I never had.
And that was my homework. I have very strong views on the points you raised, and I'm perfectly willing to speak about them when asked, but only when asked. Okay. On Elaine's point, when is the cutoff point for a binding interpretation? I think that is a good point. I would say as soon as you have a concrete dispute. I wouldn't put the point at the institution of arbitration proceedings, but where you have a concrete dispute. Besides, I would think that getting, for the states or this commission or whatever, getting its act together on an interpretation will probably take some time anyway. So I don't think they will shoot from the hip as soon as anything appears on the horizon. I think the task of such a commission would be to make give general interpretations for the future and not intervene in particular disputes, not necessarily already pending proceedings. As to the fragmentation of projected courts, I fully agree it would not be a good idea to have a number of permanent courts acting side by side, because that would just add to fragmentation, obviously. But I do realize that the Commission's idea is to ultimately aim towards one multilateral institution. Now, of course, that's not just up to the Commission. The interesting point will be whether the other players will go along, especially the United States. And I'd be very interested how China reacts to that, because China is quite different from Vietnam, obviously. Finally, finally, on interpretation and amendment that Colin Brown mentioned, you specifically said that's a legal point, but I wonder if it's not a legalistic point, because the difference between interpretation and amendment is a very fine one, and you do realize that every interpretation, every binding interpretation, narrows the range of interpretation possibilities. And if you have three different possibilities to interpret a particular provision, one is more friendly to the investor, one is neutral, and one is friendlier to the state. If you narrow that to the one that's friendlier to the state, you've obviously made a difference to the outcome of the proceedings. So I'm not sure whether that differentiation between amendment and interpretation is really pertinent.
It seems to me as well that if you're saying an interpretation sometimes will only have a prospective effect, in reality you're conceding that view anyway. But that's my view. Professor Pellet.
Well, I hate to be in agreement, but globally, I'm afraid that I agree with nearly everything. First, certainly with the last point, I think the easiest way to change a treaty really is to interpret it. And this I totally agree. Second, concerning the moment, I think the moment is when an application is made. When then you should not accept any retroactive interpretation, and the tribunal should be absolutely free to dismiss any interpretation given against the principle nemo judex. Fragmentation, okay, you will have, if this all works, you will have blocks of, say, arbitration systems. I am not sure this is terrible. In the public international sphere, which I know better, you had, for a long time, you had only one court. It was okay. So, of course, it was when the word court had said something, it was the law. Well, now you have several. And I think that in the law of the sea, for example, you have at least two Supreme Courts which could differ. What is interesting is that they try not to. The difference, of course, would be that they would apply different treaties, and then it's acceptable to have some differences. But I think that comitas gentium, judges' dialogue, and all these fashionable concepts would help to limit the inconvenience of fragmentation. And I think that multiplication of jurisdiction is the good fortune of international law and even of investment.
International lawyers, maybe, yes. You've got the mic, so...
I've got the mic. I'm not sure that it works, yes. Is it working? Okay, cool.
It's definitely
Rob House, NYU Law School. I think that we ought to be careful about substituting thought for anxiety-producing words like fragmentation. I mean, what we have now, due to the arbitrator mindset, is a kind of jurisprudential chaos. And I think that one could hardly do worse than that. On the other hand, if you look, for example, at the European Court and the Inter-American Court of Human Rights, these two courts operate in parallel, different but very closely overlapping in many respects human rights regimes. And as Ruti Teitel and I have shown in our scholarship, cross-judging, what we call cross-judging, occurs a lot. There's a lot of mutual fertilization, and yet these are distinct regimes. Once you move from the arbitrator mindset to the judicial mindset, I think you move to judicial dialogue because by nature, judges are concerned with principle and how others of a judicial mindset view principle.
I don't know if either of our panelists want to respond to that.
I could, briefly.
Very
If we have
briefly,
time.
please. Do we have time? Yes, we do have time, definitely.
Very briefly, I believe that there is a lot of cross-fertilization among arbitral tribunals. There is a lot of reference and deference. Practically every arbitral award refers to previous awards. But I also agree there is some disagreement, and there is a certain degree of chaos on particular points. My personal view is that the best solution to that would be the introduction of something that's entirely different from what is in the recent EU proposal. I believe that the introduction of a system of preliminary rulings in investment arbitration would be an idea. I've said this on a number of occasions. I've never been heard, and I don't believe I will be heard today, but I will still say it again when the occasion arises. But now I believe there's not enough time to develop this particular point.
Yeah.
To be appointed, to a panel to be appointed, which I believe is better than an appeals procedure, because in an appeals procedure, you repair something that has gone wrong. In a preliminary ruling procedure, you fix the problem before it arises. That's the issue in a nutshell.
I feel we're going to finish there. No, apparently we have one more question.
May I briefly come back to the binding declarations, and I would like to make a case for them. Maybe I'm totally wrong, but my understanding of investment arbitration is that it substitutes diplomatic negotiations between the two states concerned. So the position of the investor might be weaker than in ordinary arbitration because it's still up to the states to settle cases and if there is an espousal. So why are the two states totally cut off of a situation which in former times was up to them? I think maybe there is also an imbalance in this respect, and maybe the position of an investor is more dependent from the BIT and also the common will of the two states concerned than in a different setting.
Professor Pellet, do you want to come in? Is this right?
One sentence. I have nothing against binding interpretations, but everything against binding interpretations while proceedings are pending, because then it is one of the parties to the dispute that influences the outcome of the judicial proceedings.
And on that note, we will finish because we really shouldn't keep you from your coffee. Thank you, everyone. Thank you to our speakers.